The first fundamental right in part 3 is the right to equality. Article 14 declares equality before law. Article 14 has two components. Both are addressed to the state, and the right given by Article 14 is available to every person. The first part of Article 14 denies the state, asks the state not to deny to any person equality before law. And the second paragraph asks the state not to deny to any person equal protection of laws within the territory of India. Equality before law, that is the first part, and equal protection of laws, that is the second part. Article 14 is available to every person living in India, not only to citizens of India, but also to foreign nationals and also to corporations. Two important points emerge from Article 14. Firstly, equality before the law guaranteed by the first part of Article 14 is a negative concept, while the second part is a positive concept. Equality before law is a negative concept and equal protection of laws is a positive concept. The second important point that emerges is that the gravamen of Article 14 is equality of treatment. The basic principle underlying Article 14 is that the law must operate equally on all persons under like circumstances. And these last three words are very important: under like circumstances. The law must operate equally on all persons under like circumstances. We will elaborate on this point subsequently. First, we will take up the doctrine of classification. Here are two questions. Can there be different laws for different classes of people? In other words, is classification permitted under Article 14? Can there be classification within the limits of Article 14? The answer to these questions was given by the Supreme Court in 1954 itself in Budhan Chaudhary versus State of Bihar. This is an important judgment on the point of classification under Article 14. The Supreme Court said in this case that it is well established that Article 14 does not forbid reasonable classification for the purposes of legislation. There can be reasonable classification. But two conditions must be fulfilled before classification can be permitted. The court said that in order to pass the test of permissible classification, two conditions must be fulfilled. What are these two conditions? First, the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group. There are two categories of persons or things. Firstly, those persons or things which are grouped together, and those persons or things which are left out of that group. And there should be a distinguishing factor between them. And second condition that must be fulfilled is that this differentia must have a rational relation to the object sought to be achieved by the statute. If a statute seeks classification of people or classification of things, then there must be a rational relation to the object which is sought to be achieved by this statute. What is necessary is that there must be a nexus between the basis of classification and the object of the act under consideration. If this nexus is there, then classification is permitted. Second question. Is a law conferring discretionary powers constitutionally valid in view of Article 14? In other words, can a law confer discretionary powers to some authorities? An authoritative answer was given by the Supreme Court in 2006 in M. Nagaraj versus Union of India. And there, the court made these three important statements. First, every discretionary power is not necessarily discriminatory. What is forbidden under Article 14 is discrimination, not discretion. And the court says every discretionary power is not necessarily discriminatory. Equality is not violated by mere conferment of discretionary power. In other words, discretionary powers can be conferred and this will not be violation of the law of equality. And the third statement is this: equality is violated by arbitrary exercise by those on whom it is conferred. If the discretionary power is arbitrarily exercised, then there is violation of equality. So what is required is discretion can be given, but the discretion should not be exercised arbitrarily. Arbitrary exercise is prohibited. Discretion is permissible, its arbitrary exercise is not permitted. Next question. How is arbitrariness viewed under Article 14? Answer is given by the Supreme Court in E.P. Royappa versus State of Tamil Nadu. It is a 1974 judgment, and the court here said that equality is antithetic to arbitrariness. They cannot go together. Where there is equality, there cannot be arbitrariness. Where there is arbitrariness, there can be no equality. In fact, equality and arbitrariness are sworn enemies. The court has gone to this extent. It has declared that equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while the other to the whim and caprice of an absolute monarch. Since ours is a republic, since we have a rule of law here, therefore equality prevails here, not arbitrariness. Where an act is arbitrary, it is implicit in it that it is unequal and is therefore violative of Article 14. So this is an important point. Arbitrariness is not at all permissible under Article 14. What about reasonableness? Is reasonableness an essential element of Article 14? And answer to this question was given by the Supreme Court in 1978 in Maneka Gandhi versus Union of India. And this is the answer. Equality is a dynamic concept. Article 14 strikes at arbitrariness in state action. That this point we have already seen, that equality strikes at arbitrariness. And Article 14 ensures fairness and equality of treatment. The principle of reasonableness, which is an essential element of equality or non-arbitrariness, pervades Article 14 like a brooding omnipresence. So yes, reasonableness must be there. Arbitrariness must not be there. We conclude our study of Article 14 by listing out 4 important parameters in respect of Article 14. These four statements will sum up the scope of Article 14. In the minimum possible words, these four statements will sum up the entire gamut of Article 14. First, Article 14 guarantees equal treatment to persons who are equally situated. This is a small statement, but very important. Article 14 guarantees equal treatment to persons who are equally situated. So, equal treatment can be given only to those persons who are equally situated. Unequals are not only permitted to be treated unequally, but also they have to be so treated. So, unequals have to be treated unequally. Equals are to be treated equally, unequals are to be treated unequally. And we had seen earlier also that Article 14 is all about treatment. Third point, equal treatment to unequals is nothing but inequality, and this is prohibited. Equal treatment cannot be given to unequals. And the fourth point, Article 14 allows reasonable classification. Yes, the doctrine of classification we have studied. Right from 1954, classification is permitted. The classification must be reasonable, and this classification should be on an objective basis having nexus with the object to be achieved by the statute concerned. These are the four important points which sum up the scope of Article 14.